Turning to the merits of the protest, the record shows that the agency disqualified AGI because of the contracting officer's conclusion that AGI may have had access to competitively useful, non-public information that may have been helpful in preparing its proposal. In particular, he concluded that one of the two individuals proposed by the protester, AGI's intermediate program manager, had the capability to access files on the agency's computer system that contained competitively useful information, including an independent government estimate prepared in connection with the current acquisition, the statement of work for the current RFP, and agency budgetary information. The record also shows that AGI represented in a letter and affidavits submitted to the agency that neither of the Ambit employees that it proposed actually accessed competitively useful information during performance of the Ambit task order. Specifically, the proposed senior program manager represented that he was precluded from accessing competitively useful information on the agency's computer system because of a firewall implemented by Ambit. The intermediate program manager, for his part, represented that, although theoretically he had access to non-public, competitively useful information, he did not, in fact, access the information during any relevant time. In considering the information provided by AGI, the contracting officer queried the agency's information technology support staff to find out whether the agency's computer logs showed, one way or the other, whether Ambit's intermediate program manager actually had accessed the agency's non-public information. In response to the contracting officer's query, agency personnel advised that the agency's logs only went back some 30 days, consequently the agency had no way of determining with certainty whether or not the intermediate program manager actually had accessed the information in question. In summing up the agency's position, the contracting officer stated as follows. While the conflict of interest posed by Ambit's program manager and intermediate program manager supervising Ambit personnel who had access to procurement-sensitive information may have been mitigated by the undefined Ambit firewall, the fact that the intermediate program manager currently has access to USCIS United States Customs and Immigration Services systems containing USCIS procurement-sensitive information, notwithstanding his protestations that he has not actually accessed the procurement-sensitive information in those systems within the last year, gives rise to an appearance of conflict of interest. This appearance of a conflict of interest is aggravated by the certification by Archimedes Global Incorporated that they were not aware of any facts that create actual or potential conflicts of interest relating to the award of this task order. In light of the facts giving rise to an appearance of a conflict of interest, I am reaffirming that Archimedes Global Incorporated is not eligible for award due to the appearance of conflict of interest. AGI argues that it was unreasonable for the agency to disqualify it from consideration, principally because the agency's analysis ignored the fact that the individuals in question are not AGI employees and did not participate in the preparation of AGI's proposal. We sustain AGI's protest. In challenging an agency's identification of a disqualifying conflict of interest, a protester must demonstrate that the agency's determination did not rely on hard facts, but instead was based on mere inference or supposition of an actual conflict of interest or is otherwise unreasonable. Here, we find that the agency's decision to disqualify AGI is not based on hard facts, but, rather, on innuendo and supposition concerning the activities of the Ambit employees. Chief among our concerns is the fact that the contracting officer, without any underlying evidence, concluded that, because there was a possibility that the individuals in question may have had access to competitively useful, non-public information, that information necessarily was provided to AGI. However, the record shows that neither individual currently is employed by AGI, and there is no evidence to show that the individuals provided AGI with competitively useful, non-public information or otherwise participated in preparing the AGI proposal. On the contrary, the record shows that both individuals currently are employed by Ambit, not AGI. In addition, both individuals represented under oath that they did nothing more than give AGI permission to propose them for possible positions under the resulting task order being solicited, that they did not participate in proposal preparation activities for, or on behalf of, AGI, and that, by virtue of being bound by non-disclosure agreements, they did not share any information learned while working for Ambit with AGI. The contracting officer ignored these facts in reaching his conclusion. In particular, the record shows that the contracting officer based his finding that there was an appearance of an OCI entirely on the possibility that the two individuals in question may have had access to procurement-sensitive information. He states as follows. There does, however, appear to be an appearance of conflict of interest based upon 1. The fact that both the program manager and intermediate program manager supervised personnel who had access to procurement-sensitive information, and 2. The intermediate program manager had access to USCIS United States Customs and Immigration Services systems containing procurement-sensitive information. And at some time prior to the last year, he actually accessed those USCIS systems containing procurement-sensitive information. While the conflict of interest posed by the program manager and intermediate program manager supervising Ambit personnel who had access to procurement-sensitive information may have been mitigated by the undefined Ambit firewall, the fact that the intermediate program manager currently has access to USCIS systems containing USCIS procurement-sensitive information, notwithstanding his protestations that he has not actually accessed the procurement-sensitive information in those systems within the last year, gives rise to an appearance of conflict of interest. In light of these considerations, we sustain AGI's protest.